Friends, I think meeting can be called to order. May I request Mr. Fali Nariman and Pratap Bhanu Mehta to come on the dais. Friends, Ashok Bhai passed away during pendency on 13th April 2020. None of us could be part of his last journey. Maybe he willed it that way, as he always avoided fanfare around self. In true manner of a detached Buddhist that he was by a choice. Today, he would have been very happy to be in midst of all of you. Ashok Bhai would have winked at Fali for being such a star attraction, which of course Fali is. He would have called Pratap a crowd puller, which of course Pratap is for a lot of us. He would have greeted the honorable judges with his characteristic smile and welcomed all the friends with open arms. Ashok Bhai always loved a good dialogue, a stimulating conversation, and intellectual engagement with friends across spectrum of society. All for the sake of it, without any agenda or any point of view to push or ideology to propound. Because he believed that by such interactions, some good would come out, or at least we would understand each other better. In that spirit, first Ashok Desai Memorial was organized last year, which was delivered by Honorable the Chief Justice of India, Dr. D.Y. Chandrachud. In his inimitable style, the Chief Justice gave a brilliant talk on dynamic interplay between constitutional morality and public morality. It is available on YouTube. Today is second Ashok Desai Memorial Lecture in that spirit of dialogue for the sake of it. We begin our function with best foot forward from Chamber and family of Ashok Desai. I would request Justice Pratik Jalan to welcome all the guests. And before that, I must say that Ashok Bhai always encouraged conviviality, a good drink, and food. So after the function, it's a request that all of you please join for drinks and dinner. Justice Pratik Jalan.
Thank you, Pallav. Mr. Fali Nariman, Professor Pratap Bhanu Mehta, respected judges of the Supreme Court and the High Courts, both past and present, members of the bar, family and friends of Mr. Ashok Desai, ladies and gentlemen. On behalf of the family and the chambers of Mr. Ashok Desai, it is my great privilege and pleasure to welcome you to this evening's lecture. The idea of a lecture series to commemorate Ashok Bhai's life, as Pallav just said, is a befitting one because a defining feature of his personality was his insatiable thirst for knowledge. Knowledge not just of the law, but of literature, music, the arts, history, politics, and the works. I know the idea of these lectures would have pleased him because one of his oft-made remarks to me was in the context of the dinners that we organize periodically for the great and the good when they become greater and gooder. And Ashok Bhai always felt that those occasions would be much enriched by a talk or a topic of the honoree's interest, and preferably one well outside of the law. Conferences with Ashok Bhai were often interspersed with such digressions. One colleague speaks of Ashok Bhai being more interested in his search for a piece of Gujarati poetry he couldn't lay his hands on than in the undoubtedly fascinating facts of his case. Another reminded me recently of Ashok Bhai retelling some jokes during a conference. We were unable to understand the jokes, not least because he was reading from a Sanskrit joke book. With the thought of such a rich intellectual tradition in mind, we are delighted to have two of the foremost public intellectuals of our time with us this evening. The phrase, doyen of the bar, was perhaps coined for Mr. Nariman. He has been a senior advocate for more than 50 years, been awarded the Padma Vibhushan, served as Additional Solicitor General, as a nominated member of the Rajya Sabha, President of the Bar Association of India, and of the International Commission of Jurists. But all these remarkable achievements do not begin to capture his extraordinary position as the conscience keeper of our bar, of our judiciary, and indeed, I would venture to suggest, of our society. So thank you very much, sir. Professor Mehta is an eminent political scientist, having taught at the New York University School of Law, Harvard University, Jawaharlal Nehru University, and served as president of the Center for Political Policy Research and vice chancellor of Ashoka University. I have had, I must confess, the occasion to work with both of them and can vouch for the fact that they are hard taskmasters and do not suffer fools gladly. But most importantly for today, they are both friends whom Ashok Bhai held in the highest esteem. Mr. Nariman, of course, was a few years senior to Ashok Bhai, both at the Bombay Bar and in the Supreme Court. Professor Mehta was a generation younger, but no less respected. Ashok Bhai devoured his writings for a new insight or an unknown historical vignette. We are grateful that both of you have accepted our invitation to speak today. This is an appropriate follow-up to the first lecture, which as Pallav mentioned, was held last year in Mumbai on the eve of Ashok Bhai's 90th birthday. It is befitting that we have two speakers with us today who knew Ashok Bhai so well and worked with him in such a close capacity, as indeed did our first speaker, Justice Chandrachud. Pallav mentioned that we were not able to participate in the events following Ashok Bhai's passing during the pandemic. For many of us, juniors, traveling to Mumbai for that first memorial lecture was akin to a pilgrimage to pay homage to our revered senior. With these words, I welcome all of you this evening, both those here in person and those who are joining online. Ashok Bhai was an enthusiastic adopter of technology and would have been pleased to know that so many of you are joining us in this way. Amongst the online attendees today is Ashok Bhai's wife, Suvarna Ben, who is unable to be here physically. It is presumptuous of me to welcome her because she is our host this evening. But I do want to recognize her presence and that of their three children, Harsh, Ami, and Jay, who are with us physically. On their behalf, and on behalf of all my Guru Bhais and Guru Bahans from Ashok Bhai's chamber, I welcome you all very warmly to this evening's lecture. Thank you.
Now may I request Mr. Harsh Desai and Jay Desai to come on stage and felicitate Fali with a book and a plant. Now may I request Ami to come and felicitate Dr. Pratap Bhanu Mehta. We are privileged to have Mr. Fali Nariman as our chief guest, who needs no introduction. Fali is like a high priest or a Bhishma Pitama who has inspired generation of lawyers by his professional excellence, golden ethical standards, and deep commitment to constitutionalism. In fact, my son, my father, even Ashok Bhai for that matter, they were all inspired by Fali at various points of time. One evening is too short to talk about even few of the immense contributions in our constitutional development, rule of law, and public discourse made by Fali. Fali is an indispensable presence for any constitutional debate, whether in court or outside. Fali defies the description of young or age because he represents ageless wisdom of a sage. Even in polarized time like ours, Fali is heard and heeded by both sides. In fact, it is better that we hear Fali rather than we hear about him. I request Mr. Nariman to give his inaugural address.
Judges, ladies and gentlemen, but I just can't leave it at judges because we also have in our midst a sitting judge of the International Court of Justice, whom I warmly welcome. We are gathered, of course, here, as you are all know, for a memorial lecture to recall not only a great advocate, but a multicultural and well-rounded human being as well. Ashok and I got to know each other since we both studied in the same law college, the Government Law College, Bombay, an institution of higher learning now in its second century of academic existence. It was in the late 1940s that 5 of us, students of law, hit upon the idea of establishing what we impudently call the Law College Parliament. It survived for only a couple of years after we left. But long after we left college, we took pride in the fact that we had experimented not only with parliamentary elections, but also on how to run a parliamentary form of government after elections. This was even before India as a nation had a constitution embodying adult suffrage and a parliamentary system of government. There were 5 of us involved in this venture. Anil Diwan, whose wife Smita is here, he was Prime Minister of the Law College Parliament. Mulli Bhandari, who was the Defense Minister. Soli Sorabji was the leader of the opposition. And Ashok Desai was the Chief Whip. He was one of the more eloquent members in the Law College Parliament. And I was elected Speaker. Since we were then in British India, with the British about to depart, but not yet having departed, we also had to provide for a head of state like Britain did. And so we named our charming and venerable principal, Dr. S.G. Chitale, as king. And the king obliged us by solemnly opening each session of our college parliament with all British pomp and circumstance, with a speech from the throne, even when there was no throne, not even a makeshift one. But each of us and all our members made sure to scrupulously follow the rules of procedure that were set out in Erskine May's parliamentary practice. Yes, those were halcyon days, not just of law and learning, but also of fun and frolic, with some mock seriousness thrown in. Anil, Soli and Ashok have left us, and only Mulli and I have outlived our erstwhile comrades in arms, which is not at all a happy thought. As to why that should have been, as to why we should alone have been transported much earlier into the never-never world remains, as it always remains, a mystery. Believers like Mulli and I would say, God only knows. But as George Bernard Shaw has written in the prologue to one of his plays, if we were to know the true reason, my friends, we would be gods ourselves. At the end of last year, Ashok's family got published a commemorative volume titled Remembering Ashok Bhai. In it, his daughter Ami, who is happily with us, recalls, and I'll quote, Papa was so much more than just a father, a husband, a son, a brother, a grandfather, a friend, a mentor, a role model, and of course, a lawyer. He had a multifaceted personality, varied passions that enabled him to connect with so many, no matter their age or occasion. And then she feelingly adds, Papa never spoke a curt word about anyone, nor did he ever raise his voice, which is to me quite amazing. To have gone through life never having spoken a cruel word about anyone, nor having raised one's voice at anyone. Later in life, Ashok, as we all know, served highly successfully as Attorney General for India. Everyone came to know who he was. Like in that anecdote about the celebrated British essayist and critic of yesteryear, G.K. Chesterton. On one occasion, a gushingly enthusiastic admirer came up to him and said, "Oh, Mr. Chesterton, how wonderful it must be to be so famous that everyone asks about you and who you are." But the old boy responded rather annoyingly, "If they don't, madam, they soon ask. If they don't, madam, they soon ask." And this leads me to a story, which is a true story. Once when Ashok was in the United Kingdom, he stayed at the home of Sir Geoffrey Jowell, Professor of Public Law, University College London. On the afternoon of his arrival, Sir Geoffrey and his wife showed him his room, recommended a rest after his long journey from Delhi, and they explained to him that they had to leave the house for a short while, but that he should feel free to roam around the house and help himself to refreshments that were in the dining room. Sir Geoffrey then recalls, and I quote what the professor himself says in his own words, "When we returned to our house, we were simply horrified to see 2 police cars blocking the road, with Ashok on the doorstep, flanked by 4 grim police officers, not letting him out of their sight. You see, during our absence, someone had set the burglar alarm, not realizing that Ashok was in the house. And Ashok's movements in the dining room had evidently activated the alarm system. Appalled at the sight of 4 policemen surrounding Ashok, the professor rushed to the scene and asked what had happened. The burly chief inspector of police was proud of his catch. He solemnly told the professor, "Rest assured, sir, we have apprehended the perpetrator. He claims to be the Attorney General for India." I never heard that yarn before. So I told him, "Sure, mate, and I'm the Queen of England." The Jowells, of course, were acutely embarrassed by this entire incident, an embarrassment that was only dispelled by Ashok's composure, which the Jowells characteristically characterized as Ashok's serene amusement. It was just like him. Well, as the poet says, at the going down of the sun and in the morning, we will always remember him. But what is that word by which we will remember him? It was coined just a week ago by the Oxford University Press, and the word is charisma. Unfortunately, it has been abbreviated into 4 letters, R-I-Z-Z-Riz, which I don't approve of. Charisma sounds much more dignified. So we will remember Ashok for his charisma. Now, ladies and gentlemen, I must frankly tell you, I would have ended my preliminary remarks, leaving our distinguished speaker of the evening to address you on the topic of constitutionalism. But yes, just yesterday, my friend Pallav Shishodia sent me an email expressing the hope that as president of this function, I would express my views on a subject that was worrying lawyers as well as whom he described as political authorities. And the subject was, is there at present too much judicial interference with actions of lawmakers, namely Parliament, even when Parliament exercises its power to amend the Constitution? Well, I know I'm trenching on someone else's time, but not wanting to hog the limelight, permit me to give you my brief take. In the first 20-odd years of the promulgation of India's Constitution, our Supreme Court faced a dilemma, namely that though the higher judiciary, the Supreme Court and the High Courts in the states were empowered under the Constitution to invalidate not only executive orders, but also legislative enactments that violated any part of the fundamental rights that guaranteed in the Constitution. But whether the courts were also empowered to adjudicate on the validity of constitutional amendments passed with the requisite special majority, even where it was scrupulously followed, was something on which our Constitution was silent. With one single political party, the Congress Party, consistently returned to power at each general election since 1952 with a 2/3 majority, the judges of the Supreme Court kept plumbing the depths of silence in the world's longest constitution, searching for some limitation on the amending power. Ultimately, they said they found it, as was recorded in a decision of 13 judges in a famous case called Keshavanand Bharati in 1973. The great question before this bench was the true nature, extent, and ambit of the amending power under our Article 368 of the Constitution. As one of the justices then put it, Justice Yashwant Chandrachud, the largest bench sat for the longest time to decide issues of grave moment, not only for the future of the country, but for the future of democracy itself. In Keshavananda, 6 justices held that the power of amendment conferred by 368 was wide and unfettered. It reached each and every part of the Constitution, including the chapter on fundamental rights. And 6 other judges held that the power of amendment was limited, but the justices were all agreed, not quite agreed, as to the extent of such limitation. It could therefore be said that the court was evenly divided. The judgment that tilted the evenly divided view was of Justice H.R. Khanna, whose portrait hangs in court number 2 today. Must go and see it. And whilst construing 368, this is what he said. Although it is permissible under the power of amendment to effect changes, howsoever important, and to readapt the system to the requirement of changing conditions, it is just not permissible to touch the foundations or to alter the basic institutional pattern. In this judgment, Khanna also said, subject to the retention of the basic structure of the Constitution, I have no doubt that the power of amendment is plenary. And this quote has been authoritatively recorded in a later judgment of a bench of 9 judges as the majority view rendered. A good American judge once said that the power to declare the law, this was Justice Cardozo, carries with it the power and within limits the duty to make law even where none exists. And in Keshavananda, in reading implied limitations in the amending power, the Supreme Court had certainly made new law. The majority view in that case was criticized as an unwarranted assertion of naked political power in the guise of judicial interpretation. Frankly, it was. It upset the balance of power in the Constitution. By propounding the basic structure, the guardians of the Constitution, it was said, had at one bound become guardians over the Constitution. Constitutional adjudicators had assumed the role of constitutional governance. The criticism, to some extent, was valid. After the 1971 general elections, with the Congress party getting an overwhelming majority in Parliament, India might have moved into a state of grave constitutional crisis. But then, fate intervened in the form of a fortuitous event. On 12th June 1975, Prime Minister Indira Gandhi lost the election petition filed against her by Mr. Raj Narayan in the Allahabad High Court. Raj Narayan had contested against Mrs. Gandhi and he had lost. The extraordinary had happened. A Prime Minister in office who had a fantastic majority in Parliament had been unseated. Whilst her appeal to the Supreme Court was pending, the internal emergency with ominous consequences was imposed on 25th June 1975. And in addition, and this is very important, the Constitution 39th Amendment Bill was hastily drafted and even more hastily passed by Parliament. All in 3 days in August of that fateful year, when Mrs. Gandhi's appeal was scheduled to be heard by the court. The power to amend the Constitution was invoked virtually to strike out an item already listed for hearing before the Supreme Court, namely the election appeal of Mrs. Gandhi. The Constitution 39th Amendment Act provided, notwithstanding any judgment or order of any court, the election of a sitting Prime Minister could never and would never be deemed to be invalid or void. The judgment of Justice Jagmohan Lal Sinha of the Allahabad High Court holding Mrs. Gandhi guilty of corrupt practice under election laws was attempted to be reversed by a constitutional amendment so as to preempt the Supreme Court deciding Mrs. Gandhi's election appeal. Now, fortunately for the nation, the court resisted this crude attempt, relying for the first time after Keshavananda on the basic structure theory of the Constitution. It was this decision, and not the majority decision in Keshavananda alone, that helped to cement the basic structure theory and give it added constitutional validity. In Indira Gandhi versus Raj Narayan, a constitution bench of the Supreme Court held, under compulsion of a monstrous law, that free and fair elections were a fundamental part of the Constitution, so fundamental as to be beyond the reach of the amending power. The judges said that legislatively validating an invalid election without changing the law that made the elections invalid would toll the death knell of a democratic constitution, and that making an election immune from challenge and preventing questioning of the election before any forum, howsoever serious the improprieties, was subversive of the principle of free and fair elections in a democracy. This decision constitutes, and you must always remember this, the high watermark in the assertion of the court's judicial power in the teeth of what was then a very determined majoritarian regime. If the pernicious clauses of the Constitution's 39th Amendment had been upheld, democracy as it was projected in the Constitution would not have survived for long. Now, what's the background to this? A famous international academic jurist, Ronald Dworkin, had a theory about the legitimacy of judicial governance. Present-day judges, he said, who may have had nothing to do with the written constitution when it was framed, by reason of their position as judges, have become and must act like partners with the framers of the Constitution in an ongoing project, since it is and always will be an ongoing project, namely to interpret a historic document in the best possible light. These were his words. And the basic structure theory was the response of an anxious and activist court to the experience of the working of India's constitution during our nation's first 25 years. Or, as Ronald Dworkin would have put it, a historic document, India's constitution, was interpreted by the Supreme Court in the best possible light. But what is far more significant is that 50 years, almost 50 years after the basic structure theory was first propounded in Keshav Ananda's case, Parliament itself gave implicit recognition to it in the Constitution 44th Amendment Act 1978 by declaring that the fundamental rights guaranteed by Article 20 and 21 of the Constitution, the right to life and liberty, could never be suspended even during an internal emergency, because the directions in respect of these articles were basic to the constitutional framework, which was done by resorting to an amendment in Article 359(1) of the Constitution. In the 45 years after 75, the basic structures theory has not been disturbed, but kept in place, perhaps by not being invoked by the court too often. In the nearly 50 years apart from the decision in Indira Gandhi versus Raj Narayan of 1975, the basic structure theory has so far been applied by the Supreme Court in only 5 other cases. So you will see that the doctrine of basic structure has come to stay, having been accepted by Parliament itself. And having got this off my chest, ladies and gentlemen, after apologizing to the Speaker of the evening for taking up his time, may I say 1 or 2 words about my dear friend, Pratap Bhanu Mehta. To me, his great claim to fame is that he is a professor at Princeton, New Jersey. And if you look up Wikipedia, as I have, you will be informed there are as many as 75 Nobel Prize winners who are affiliated to Princeton University in New Jersey, either as alumni, faculty members, or researchers. And I must also inform you that at Princeton and at nowhere else in any other university in the world, there's a car park specially reserved only for the cars of Nobel Prize winners, because there are so many of them. So ladies and gentlemen, give Pratap Bhanu Mehta a big hand.
Many thanks, Fali. You know, originally Fali assigned 10 minutes to himself. And I said, we can't be taken so casually. And also, we are not yet ready to give Fali only a ceremonial role. We are very, I think I was very correct. So wonderful to hear you both on your love for Ashok Bhai and everybody of your batch, and also on the basic structure. Now for the next speaker, let me begin with a disclosure. Dr. Pratap Bhanu Mehta is my brother-in-law, one of the several eminent brothers my wife has. And you know how difficult it is for Indian male to praise brother-in-law, that too in public. So I would not talk about how brilliant young Pratap became a distinguished scholar at Oxford to complete his education there. I would not talk of his being one of the youngest professor and dean at Harvard. Now he teaches at Princeton. But I would not talk of these centers of academic excellence, because these days Indian universities, whatever they are the best. I would also not talk of Pratap's stint as a Vice Chancellor of JNU, as a member of Knowledge Commission. Now we don't need it, because we have discovered that our ancient wisdom is complete. I would also not talk of Pratap as Vice Chancellor of Ashoka University, or as one on the editorial board of Indian Express and regular contributor to it. The reason Pratap is here is not me. For me, he's a professor I never had, though I get ample opportunity to pick on his brain. The reason he's here is because Ashok Bhai was very fond of him. I remember Ashok Bhai would ask me from time to time about Pratap and was always game for an evening with him. We all know Pratap as a public intellectual whose fearless criticism of powers that be is inspired by a vision of higher human conduct and better society. You may agree, you may disagree, or you may criticize Pratap, but you cannot ignore him. He always provokes you to think and reflect on your position. I'll request Dr. Pratap Bhanu Mehta to give his keynote speech.
Suvarna ji, Desai family, and the extended Desai family, all his juniors, all of you gathered here. I can't tell you how deeply honored I feel to be part of this occasion. And you must also have some pity for me, because Fali Nariman is a hard act to follow. And this extraordinary group of people in this room, which is really, I think, the best tribute, and I think gives you a profound sense of just the kind of imprint and legacy Ashok Bhai left. What can one say to this group of people? I won't go over Ashok Bhai's remarkable career as a lawyer, as a professional. Just to say that extraordinary word, he was a real mensch in every sense of the term, and of the kind, a species that is becoming increasingly rarer. He was always extraordinarily kind, welcoming, and I like Mr. Nariman's phrase, that serene humor that he had was truly extraordinary. The subject I've chosen today to speak about, usable past and constitutional history, is an academic subject. I'm not a lawyer or a jurist. And I chose this subject with mixed feelings. I think Ashok Bhai would have approved of the academic discussion. But the one thing, if all of you remember with Ashok Bhai, was that he always spoke extempore, and he was always extraordinarily witty, funny. And it's the second burden that I fear I will not be able to carry in quite the way that Ashok Bhai did. He had a way about him I mean, the last sort of, I think, public event I did with him, I think was at the Jaipur Literary Festival. There was a panel on the Constitution with Ashok Bhai, Madhav, Chintan and me. And before that, we were sitting in the author's lounge the Jaipur Literary Festival had. And a young lawyer from the Jaipur bar showed up. And as lawyers do, was trying to get a lot of constitutional law from Ashok Bhai, but was also trying to get a lot of gossip from Ashok Bhai about a particular case. And at some point, Ashok Bhai very artfully, we know all Ashok Bhai was a great lover of music, right? He had collections of classical music, Western music, Indian music. But at some point, Ashok Bhai very artfully said to him, after he asked a question that perhaps had crossed a line, Ashok Bhai said, put his hand on his shoulder and said, "Hum bolega to bologe ki bolta hai." I wonder if he were here today, he would have said we should have adopt this as our national anthem. But anyway, I'm also glad that Mr. Nariman gave that wonderful introduction to the idea of basic structure in Indian constitutionalism, because actually that's going to be the starting point of what I'm going to be speaking about today. There are many ways in which you can think of the relationship between history and constitutionalism, right? In 17th century England, apparently, judges used to be given didactic books about how to judge. And the purpose of those didactic books was to inculcate the right kind of character in judges, right? So it's not just the technicalities of law, but really what are the virtues that the activity of judging involves. These days, I'm not sure law schools or any academic institution is in a good position to talk about character, but certainly in our oral cultures, right? This is something we talk about. This is one didactic use of history. I'm from a town of Jodhpur, and there is a very famous lore in the Jodhpur bar, a didactic story about a judge. This is a judge in princely India. There's a particular case involved in which the prince, the Maharaja of Jodhpur, has an interest. And the Maharaja of Jodhpur sends a signal to this particular judge that he would like an outcome of a particular kind. Let's put it this way. And the story goes, this judge delivers the judgment. The judgment goes against the Maharaja's wishes. The judge comes home and writes a resignation letter to the Maharaja. It says in Marwari, Rajya vaste matho de saku iman nahi. I can give my head to the state, but not my integrity. Right? So there's this kind of whole tradition of this kind of didacticism, use of didactic sort of stories of judging to think about what preserves constitutional values. There is a second form of history writing, much more academic, and I think it's also reflected in Mr. Nariman's opening remarks, which is that the construction of usable paths in thinking about constitutions. It's becoming increasingly common in America, England, and India. And there's a certain kind of wiggishness to this history, where we tell the histories of our constitutions in terms of these key ennobling moments, right? The basic structure as the foundation of the Indian Constitution, and then sort of everything else leading up to it. And then once that moment was arrived at, everything flows from it. Think of the histories of American constitutionalism produced in the last 25, 30 years. Think of Lawrence Tribe's, right, great textbook on American constitutionalism. It's very much a product of the kind of Warren Court conception of the American Supreme Court, right? The American Supreme Court as this kind of custodian of constitutional values and liberties that finally recognizes the truth of American constitutionalism and uses its power to uphold them, right? One of the striking things about a lot of these histories is that the mood in which these histories are written often depends on the mood scholars and the public at that moment have about the Supreme Court, right? So during the Warren Court years, and Ronald Dworkin is very much a product of that conception of constitutionalism, right? the judge as this kind of moral arbiter. I mean, if the world was only the Warren Court writ large. Or in India, that kind of nostalgia about that basic structure moment, right? If the Indian Supreme Court was just that brief moment writ large, all would be well with our constitutional democracy. But as the authority of courts wane, right? And by the way, these kinds of moments are much rarer in our constitutional histories than we care to acknowledge. Courts have 3/4 of the time not been friends of liberty, not been friends of constitutional democracy, whether it's in the United States or India. But those histories are often told or retold in moments when constitutionalism once again is in crisis. And I think what's interesting about this moment, if you see the kind of historiography that's coming out, just see the submissions to the US Supreme Court's, the reform, the Congressional Commission, bipartisan commission on Supreme Court reform, right? Actually, except for a 25, 30-year period, the American Supreme Court has a pretty ambivalent and dark relationship to democracy, right? And it is an interesting question to ask when the historiography of the contemporary court is done, right? Right, at this particular moment where its authority is being challenged in so many different ways, will that history have a different cast? So that's just my way of kind of preliminary introduction that in a way, one conception of a usable past that we have, the way we write the histories of our courts, depends very much on the mood of the moment about the nature and authority of the court. Okay? And we may be returning to a much more skeptical time. But today what I want to talk about is a history in that slightly skeptical vein. I won't be talking about India too much. I want to focus on this moment because there is consensus across the world that there is a crisis of constitutionalism gripping the world. There is increasing skepticism about constitutional courts. That Warren Court moment, that basic structure moment, has in some senses passed our constitutional democracies. Most liberal democracies are backsliding or facing the danger of severe polarization, right? And it's in this context that we might want to think about the histories that we actually begin to tell ourselves about what our Constitution is, what it does, and how the Supreme Court actually carries out its mandate. Now, a quick schematic way of introducing this topic is to begin with a joke. I think it's the German scholar Christoph Mollers who once made this joke about constitutional law, that it was not Francis Fukuyama who invented the end of history. Remember 1989, Francis Fukuyama's great claim. We are at the end of history. The most important normative questions about the frameworks that should govern society have been settled, right? He was not saying that there will not be events, that there will not be conflicts, but none of those conflicts, right, would ever replace or challenge that basic 1989 liberal democracy framework that was in some senses emerging. And Christoph Muller's joke was that actually it's not Francis Fukuyama who invented the end of history. It's actually lawyers and jurists. If you reflect on the basic structure doctrine, what is the basic structure doctrine? Thought of in historical time, right? It's a claim that there is a basic structure to the Constitution that embodies normative values that cannot be surpassed. Any permissible range of conflict in society must take place within the bounds of that basic structure, right? So it's not saying that constitutions won't change. There will be amendments. There will be legislative enactments of various kinds. But fundamentally, they will be contained by, or they will be considered legitimate only if they operate, as Mr. Nariman said, within the boundaries of this basic structure, right? But if you think about this, this is actually quite a peculiar historical doctrine, right? Has constitutional history ended with the basic structure in the deepest sense of the term of constitutional history, right? which is that everything that comes after basic structure is simply a series of footnotes to that eternal constitutional legal truth that the basic structure has enshrined, right? The basic structure is like our version of the Sanatan Dharma in some ways. It is eternal, it will remain no matter what, and like the Sanatan Dharma, all of us, citizens, jurists, law professors, will keep sort of, in a sense, reciting that mantra, right? As in some senses the pinnacle of our judicial horizons. So in some senses, this is a constitutional history, like with the constitutional history of the Warren Court that you find in Lawrence Tribe's great, textbook on American constitutionalism. It actually is a history that arrests time, right? The peak and summit of constitutionalism has been reached with the basic structure. And what I want us to think about is how peculiar this idea actually is in the history of constitutionalism, right? We take it as kind of self-evidently part of our kind of common sense. But nobody before before World War II actually, practically for that matter, Warren Court, before the basic structure in India, would have actually thought of constitutional history that way, right? That there could be a version of constitutional history where the Constitution arrests time, right? It, in a sense, fixes values. Now, one way of seeing the peculiarity of this is to actually reflect back on maybe 2,000 years history of constitutionalism in almost all societies. If you looked at Western juristic thought, Western political thought, anybody, you can just pick anyone, Plato, Aristotle, Cicero, Polybius, Machiavelli, Hale, Koch, just name your pick, right? They would all have, for them the constitutional problem was that the Constitution is always in flux and change. There is no fixity to it, right? The constitutional problem was, how do you prevent constitutions from being transformed from democracies into oligarchies, into tyrannies, tyrannies back into democracies, oligarchies, democracies, and in some senses the cycle continues, right? For them, constitutions cannot arrest time because constitutions are preeminently historical. They exist in this ebb and flow of events, and they are predominantly located in relationships of social power, right? They're not these abstract arrests. We have arrived at the highest values, right? Think of the Roman constitutionalism, for example, right? The constant oscillation between republicanism and authoritarianism, right? 17th century England. But the point I want to make is that for almost all of these ways of thinking about constitutions, right? This idea that simply the promulgation of a value, a basic structure, can arrest the flow of constitutional change and constitutional time would have seemed utterly, in some senses, bizarre. Now, you might push back against this, and I'll talk about this contemporary relevance of this idea in a second. You might push back against this, and you might say, look, what about ancient constitutionalism in 17th century England, right? After all these societies also had a version of constitutionalism where constitutionalism drew upon memories of what they called immemorial custom. In fact, prior to the 19th century, the two standard meanings of the word constitution were either constitution referred to the literal constitution of society, right? And that literal constitution of society is encapsulated in the customs of its people, right? So in a sense, all customary law is constitutional law. To be a society that is constituted is to be a society that is in some senses governed by custom, right? So law or constitutional law, as we understand it, as this specialized realm of a basic framework, that idea was in some senses very alien. Constitutional law in this sense, in the sense of custom, was actually a live social reality. you did not look for it in abstract pronouncements. You looked for it the way you look for language, in the actual usages, social practices, in some senses, of the society. And this is the kind of the genesis of the historical school of constitutional law that the Germans propounded in the 19th century, right? That the way to write constitutional histories is not the constitutional histories as the enunciation of doctrines, right? But capturing, in some senses, this complex amalgam of customs. Now, the reason the identification of customary law and constitutionalism and this appeal to customs from time immemorial was important to this entire tradition is because they thought of custom as possibly being the only check, or one of the few checks, on the arbitrary power of monarchs, right? If you take any Indian text from political science, take Kamandak's Niti Sar, right? All constitutional traditions have a suspicion of arbitrary power. I can't think of a single tradition of thought that openly licenses absolutist power. But if you ask the question, what limits the king's power, right? The answer frequently will be, it is actually custom that limits the king's power. The king cannot transgress the boundaries of custom. And it is for this reason that in the 19th century, so many constitutional histories thought of histories of customary law as being very central to thinking about the preservation of liberty, right? Because this is the only effective power that in some senses that can check absolutist power, right? And custom evolves slowly. As I said, the analogy with language is something that attracted, Hayek about common law and customary law. It evolves slowly. It is actually instantiated in the life worlds of people, right? It doesn't have to be in some senses enforced by command. This made customary law in some senses hugely attractive. But the second feature of constitutionalism, so I said pre-modern features, one is this emphasis on customary law as a check on arbitrary power. But the second check on arbitrary power, and this one is more important for our times, we'll see in a second, was that before the 19th century, almost every form of constitutionalism that we know of openly represented the balance of social power in the Constitution itself, right? If you think of the English Constitution, or the assemblage, that entire assemblage that we think of as the English Constitution, the powers of the aristocracy and the monarchy in some senses are enshrined in the Constitution. The Constitution itself represents the nature of social power. It's a feudal constitution, right? We think of Magna Carta as a charter of liberty, but Magna Carta was also, right, a charter of feudalism that openly enshrined the power of aristocrats. By the way, it was also an anti-Semitic charter. We forget about that. It regulated interest payment recovery by Jewish bankers. Okay? It's amazing how you can construct usable paths out of these wonderful sort of documents. Be interesting exercise to do something similar for Indian history. What are those key constitutional moments? But the most important thing, as I said, for these constitutions was that the Constitution openly represented the balance of social power as existed in that society. And if that balance of social power changed, the Constitution would by itself change. This is the classic theoretical problem of the one, the few, and the many. Do the one rule, the few rule, or the many rule, right? The monarch, the oligarchs or the aristocrats, or the many, not the demos at large, because there was slavery in many societies, but certainly commoners in some senses. And the core constitutional problem was, how do you create a structure that represents this balance of social forces in a way in which, right, some kind of harmony or equilibrium can be maintained? That was the core constitutional problem. You might say, to put it slightly provocatively, before the 19th century, everybody was Marxist about constitutions, right? And the purpose of good constitutional design was to see if these different constituent elements of society could actually work together in balance, right? But they had no doubt that constitutional history will not be arrested by ideas like the basic structure or some edicts pronounced from law courts. That can't be the end of history. It is going to be the nature of social power that propels constitutional change, right? And it is striking how much that idea has dropped out of contemporary constitutional history. Again, just to give examples, right? Almost every constitution till the 19th century so openly represented social power. The American Constitution, 1776, right? At one level, it has one foot in modern constitutionalism, with its promise of individual rights, life, liberty, and the pursuit of happiness. But at another level, it has another foot in constitutionalizing a structure of social power, namely the power of Southern slaveholders to hold slaves. So 1776, interestingly, is both a revolution of liberty and it's actually an anti-liberty royalist revolution as well, right? Because part of it is, in a sense, a reaction against Britain abolishing slavery. Think of the constitutional reform debates in 19th century Britain. What is amazing is till the 1870s, the debate over constitutional reform in Britain, right, largely centered on the debate over the reform of the suffrage, extending the suffrage. But the fundamental premise that protagonists shared in that debate was that Parliament needs to be a mirror of society, right? The composition of Parliament has to be constitutionally enshrined and constituted in a way that it once again formally represents the balance of social power in society, right? Now, in this case, it was increasingly labor instead of aristocrats and others. So till the 19th century, as I said, it was almost an axiom of constitutional histories that a constitution represents social power, and as the balance of that social power shifts, so will constitutions. There is no eternal arresting of this history by a normative plateau or an idea like a basic structure, right? And the argument was that actually taking into account the social power provided for the right kinds of checks and balances that would preserve liberty, right? So English constitutionalism, it's actually the balance between the monarchy and the aristocracy that is going to be the guarantee of liberty, those Magna Carta rights that we in some senses so value, right? Without thinking of this balance, you cannot actually think of liberty or constitutionalism at all. Okay. Now, in the 19th century, this version of constitutionalism gave way to something like our basic structure version of constitutionalism because of 5 major changes. I'll be sort of quick about this. The first major change, obviously, was that the logic of custom faded, right? Custom had its advantages that it did provide a certain kind of check on arbitrary power of monarchs. But the disadvantage of custom, particularly under conditions of modernity, is that there was no justification for most of the customs that were in fact enshrined in social practices and social relations. So under conditions of modernity, custom had to be replaced by consent and justification. Every single thing that we think of as law, right? No modern court can entertain the proposition that if you came up and said, Why is this justified? Oh, this is custom from time immemorial. It's not even a move that is available to us. Now, some lawyers might argue that stare decisis is our legal version of custom, right? Precedent in some senses given authority. But I think that's a very misleading interpretation of how precedent actually works in law. But the crucial point is, as I said, that conception of law faded precisely because every single aspect of society had to be now subject to the logic of justification. And one aspiration of all modern constitutionalism is not just the arresting of time by these eternal values called the basic structure, but to create the conditions where the practices of public justification of every single coercive law in society can be carried out, right? So custom goes out. It just isn't a thing that exists or has authoritative weight. The second thing that happens, 18th century, is the logic of formal equality, right? So once we have declared, with some qualifications, we're still talking about men in the 18th century, but you get the general idea that all men are equal, at least in the 18th century version. Then the distinctions of status that are central to pre-modern conceptions of constitutionalism also vanish, right? Because on this view, there is no other social power that can be given legitimate constitutional weight other than the people, right? We are all now free and equal people, at least formally, right? And one consequence of that is the idea that no constitution can enshrine any status-based allocations if it is to be a constitution that recognizes egalitarianism. The third big change, and this is quite a profound change, quite relevant to us, was the rise of individual freedom. A constitution could represent the balance of social forces when the balance of social forces was relatively fixed, right? Individuals were primarily recognized by the social identity they possessed. I'm an aristocrat, you're a lord, you're a serf, right? Whatever, in a sense, the compulsory identity that society had assigned to you, right, was in some senses the social reality. It assumed that groups are relatively fixed in terms of the group status they have. And it also became painfully obvious by the 18th to 19th century that as societies become more complex, there are too many cross-cutting groups to be represented in terms of status. So if you look at the English debate over the Reform Bill, right? As I said, till the late 18th century, 19th century, it is still very much this debate. Who are the different social groups that need to be represented in Parliament such that we can call Parliament the mirror of society? Now, in England, as I said, there were largely economic groups with some tinge of status. You could say they're nobles, they're aristocrats, there are lords, there's the new rising bourgeoisie, there's the capitalist, right? If you do an Indian version of this, if you see our princely constitutions in the late 19th, early 20th century, many of them, right, had again this idea of group representation, because that's what a constitution is. The constitution simply expresses the balance of social power, right? But in the 19th century, this thorny question arose: why do we divide society into particular kinds of groups and privilege them, right? We take it obvious that the kind of diversity that needs to be represented in the social structure of constitution must be gender, caste, class, religion. But is that all to the forms of diversity that need to be represented, right? What about cross-cutting cleavages? And what about the fact that individual freedom will almost always be in tension with this descriptive representation, right? Because descriptive representation requires or presupposes that I am a representative of a particular caste or class if I act in a particular manner appropriate to the interests of that caste and class. Otherwise, what's the point of this representation, right? So this incredible tension between the social representation of the balance of forces and individual freedom, right? And so we kind of jumped that whole notion of representation to something like a modern pluralist democracy. Now, in some countries like India, some aspect of that, the idea that the constitution should represent, right? The constitution of social groups in society still lived on, in part as a kind of anti-discrimination device. But the logic of modern democracy and modern constitutionalism is much more abstract, right? The fourth change, so this individual freedom, equality, was the rise of the doctrine of sovereignty. Now, again, I'm being very schematic about it. In the 16th century with the Civil War, as you know, in part occasioned by wars of religion, but in part the English Civil War was a product of the fight between the Crown and Parliament, right? It became palpably clear that the aspirations of pre-modern constitutionalism, right, which is to secure the joint activity of different and competing social classes, right? Remember, it's Crown in Parliament. The idea in some senses is that the Crown and Parliament work together, that aspiration is no longer being fulfilled, right? Hobbes's innovation in this account of sovereignty was very simple. He said, look, boss, it has got to be clear that there's only one boss here. That's the doctrine of sovereignty. You have to decide, in the case of conflict, who is the ultimate arbiter of that conflict, right? Okay. So the pre-modern constitutional idea that sovereignty could be jointly produced by sharing power within groups began to be seen as a complete oxymoron. I mean, right? Particularly if you have conflict between those groups, because then you have to answer the question, who in some senses has final authority. But the 16th century conception of sovereignty went even one step further, right? It did not simply say that a good constitution has to settle the question of who is the sovereign very clearly. It also has to concede the fact that all morality is internal to the idea of sovereignty. Right? And this is very important for our secularism debates. We often think of the distinction between religion and secular as a self-evident distinction. This is secular, this is religion. You know, when are the boundaries of secular church and state being transgressed? The 17th century fully understood that the boundaries of what constitutes religion and what constitutes the secular will always be created by sovereign power itself, right? That's what our essential practices test is, right? It's not, as it were, the picking up of some realm called religion and protecting it. It is the state and sovereign power deciding what it thinks are the boundaries between legitimate expressions of religion and illegitimate expressions of religion. So with the rise of sovereignty, and the same thing applied to morality, right? Hobbes's very simple claim. If you disagree, it could be about anything. It could be about abortion. It could be about property rights. Who decides? So the question of authority, who decides, becomes the prior moral question, right? And all morality and religion has to be in some senses subsumed under the logic of sovereignty, right? There is no outside morality, outside of sovereignty. Because to think there is a morality outside of sovereignty is to actually undermine sovereignty, right? It is to actually think there is an answer to the question that is different from the one that the sovereign is giving, right? So shared sovereignty, this idea of a kind of balanced constitutionalism that most of these thinkers had pinned their hopes on, begins to become a non-starter. Then the question becomes, who decides? Who is the sovereign? And by the 18th century, the answer we settle on is it's the demos that is the sovereign, right? The people as a whole. There is no other legitimate sovereign. But, and here is in a sense the question people asked, but is the people itself bound by something? When Edmund Burke said, a most perfect democracy is going to be the most shameless thing, right? What he meant was this very particular thought: if all morality and religion are internal to the exercise of sovereign power, and the demos is sovereign, is there anything that can contain the demos, right? If you say something can contain the demos, sovereignty goes. If you don't say anything that contains the demos, you have this, in some senses, fear of unconstrained power. And then liberals came up with a very brilliant conjuring trick, which is the basis of our constitutionalism. That's the heart of the basic structure. They said, maybe there is something in the idea of the people itself that can provide moral restraints on the people, right? So we came up with this idea that a people, in order to be a people understood as a demos that is sovereign, it can be a people only if it is freely constituted, right? So we are not a demos because somebody has said us, we are a demos because we freely consent, right, to being part of this collectivity, right? But if you say a people can be a people only if it is freely constituted, then you have to secure the conditions of that freedom, right? In the French Revolution, what was happening was every political faction was saying, we are the people, right? Right? Robespierre stands up and says, I'm the people, right? The Girondins saying, I'm the people, right? So in order for us to ascertain who the people is and what the people want, we have to ascertain, we have to preserve the conditions of free choosing under which they can be a genuine people. And out of this idea was born the question of, in some senses, basic rights. Now, it's very fashionable to say these days that there are things called illiberal democracies, right? Fareed Zakaria popularized this term. It's very common in public discussion these days. But if you take this conceptual line of argument, then illiberal democracy is a complete oxymoron. It's a complete oxymoron because every assault on liberal freedoms is also an assault on the free conditions that allow for the demos to exercise their power freely. So think of freedom of expression, right? I mean, it's very tempting to say this is a liberal freedom, right? It's not part of democratic sovereignty. But if you think of freedom, a people can be constituted as a people, only if each one of us is in some senses freely exercising our rights to expression, consent, what we think of this conception of the people, then liberalism and democracy actually come to be tied together very closely, right? They are conceptually deeply related. Just drop the idea of illiberal democracy. It's a complete red herring. And historically, it's borne out by the fact that almost everywhere that you find an assault on liberal values, free expression, freedom of association, it's after all one of the things through which we form freely as a people, everywhere that you have an assault on liberal freedoms, an assault on democracy will follow, right? So if you actually are one of those people who says, no, we don't want to be liberal, but we want to be democrat, right? You're probably deluding yourselves. Right? But it is out of this conception that modern constitutionalism was born. The basic structure. Those ideas, values, and laws that preserve the conditions of freedom by which we can constitute ourselves into a demos, right? The conditions that force us to be free in some senses, right? Now, I just want to take a 2-minute digression, and I'll sort of just two big points I want to say what the implication of this is for our present moment. But I just want to make one little digression. It's an interesting etymological story. So when thinking about this lecture, I was trying to think of the Sanskrit term Samvidhan, right? The Hindi term Samvidhan, which we use for our constitution, right? And the etymology of this, the philosophical etymology of this word in our historiography, right? Most scholars argue that the modern use of the term Samvidhan is actually attributed to this great Sanskrit scholar Raghuveer, who is father of Professor Lokesh Chandra, the great art historian. Raghuveer was this astonishing scholar. I mean, he knew 18 languages, did the Sanskrit-Mongolian dictionary, a 9-volume Sanskrit dictionary. And to him is credited the modern use of the term Samvidhan. And it's etymologically really beautiful, right? So sam is together, right? Working together. Vi, in its upsarg prefix, is working together in a particular way, in a vishesh way. And it in some senses transitions into the vidhan, which is of course the mimamsa sort of word for, in some senses, injunction or ruling, right? And what's so beautiful in some senses about this word, samvidhan, it is that it is the act of producing a constitution together in the right way that produces the constitution, right? It's not an object that exists by edict, right? It's not an object that exists in these black letters of 600 pages of Durgadas Basu or whatever, right? It is the act of producing together that produces it, right? It's a very deeply and politically generative idea of the Constitution. Very much in some senses in the spirit of this Constitution history that I'm telling you, right? The demos is sovereign, all of us, some, right? Produce it together in the right way, right? Now, for liberal constitutionalism, the right way is that way which preserves our freedom. That is the very precondition for that democracy, right? And only then does it take the form of that injunction, right? So the Samvidhan is not what the court says it is. The Samvidhan is what we all produce. Now, this was in some senses the revolution Raghuveer kind of brought about in our thinking of the word Samvidhan. I mean, Samvidhan is an old word. Mahabharata and Ramayana have amazing references to it. Krishna is described often as, when the Mahabharata refers to Krishna, is the one that makes the plan, the arrangement, right? Samvidhanasya Mahapragyasya Chakre Janardana, right? The one who makes the plan. Or one of my favorites from the Adi Parv, it's a really nice one. You know when we do Havan, we offer Samvidha, right? Again, etymologically related to Samvidhan. Panchabhya iv bhutebhyo lok samvidhanatraya. And the translation is, like the 3 worlds have evolved from the 5 elements, the inspirations of all poets flow from, in some senses, this offering. And so what this word directs us to think of the Constitution not as morality given through us to an edict or a speech, right? But think of it as a daily poetry that we have to produce together in the right way by what we offer to each other, right? Extraordinary, actually generative conception of Samvidhan. So, this is the good news, right? We arrive at the basic structure. What's the bad news? Okay, and this, just maybe 2 or 3 more minutes on this. The bad news is, so remember in ancient constitutionalism, that pre-modern constitutionalism, there were two theories of checking arbitrary power. One was based in custom. The king shall not interfere in custom. The other was social checks and balances, which are constitutionalized. So the idea that it's getting that balance right, that will preserve the harmony of the constitution. Until the 19th century, at least in Western political thought, most people thought of the mixed regime, whether it's in the Aristotelian form, one that harmonizes, the imperatives of the one, the few, and the many, as possibly the most stable one. But here the mixed regime, as I said, was not an abstract idea. The mixed regime actually referred to the real composition of social forces in society, Now, of course, that's gone. Custom is gone. So, what checks this power, Now, there are lots of things that I won't kind of go into that history, the innovation of American constitutionalism to say, well, the one thing that can check this power is the power of faction itself. If you can divide the demos into different transient competing groups, it can function as the functional substitute of that older social distribution of power, So factions became very important to democracy, this pluralist democracy that we talk about, The downside of factions is, could a liberal democracy conduct itself in a way where the distribution of factional power is such that decision-making becomes almost impossible, It's a dilemma the American constitutionalism is facing now in a crisis that's very severe and unprecedented. The very thing that made that constitution a success, These lots of checks and balances, parceling out majority power into different factions. A lot of people are beginning to say this factionalism is exactly what is coming in the way of us being able to act as a unified nation and an agent at all. And there are parallel arguments in India, this kind of suspicion of fragmentation and coalition, So factions is one. The second, in a sense, was the independence of standing armies. Pre-modern constitutionalisms, by and large, worked in contexts where you had mercenary armies, citizens' armies, very few standing armies. And so the question is, could the standing army, if the standing army chose not to use its coercive power, liberal constitutionalism could be preserved. But, and the third and final innovation, and this is the really last point, which is the invention of the doctrine of separation of powers. Now, Montesquieu, who was a big admirer of mixed constitutions in the British Constitution, realized that because this distribution of social power is no longer going to act as a check on absolute power, particularly under democratic conditions, is it possible to think of a form of separation of powers that can do that job of instilling rule of law, The core of rule of law is that you must not be a judge in your own cause. The executive must not act arbitrarily. Now, the separation of powers doctrine has actually not worked out very well in the history of constitutional democracy, It has not worked out very well for two reasons. One, because in almost all democracies that we know, the ability of legislative power to hold executive power to account has diminished. And it is diminished for a reason that liberal constitutionalism did not anticipate, which is the rise of party politics, So once you have the rise of modern 19th century party politics, the partisanship in the legislature and the executive lines up neatly in one direction. And most surprisingly, this is even true in the United States, where their separation was the cleanest. In parliamentary governments, legislative and executive power always had a close relationship, right? But you just think of the impeachment politics, right? Trump, everybody lines up one direction. Bill Clinton, everybody lines up one direction. Under conditions of party politics, parties are good for democracies in many ways, but parties are not good for the separation of power between legislatures and executives, right? So that's one reason in some senses they broke down. But the second reason why the separation of powers broke down, and that has to do with this particular group. So Montesquieu's hope was that the way in which the separation of powers would preserve liberty and constitutionalism is by acting like a surrogate class competition, right? Remember, in older constitutional schemes, different groups have to compete with each other. Aristocrats would keep a check on the monarchs and so forth. What if, and this is a term my friend Jacob Levy has used very nicely, I like this term, the jealousy of offices, right? What if the separation of powers created distinctive professional identities where it was in the interest of particular professional identities to act as a check and balance on the power of other professional identities? Politician is one professional identity, judges and lawyers are another, right? And in the 19th century, till the early 20th century, practically, what is striking is that every discussion of liberal democracy, pick up Durkheim's Professional Ethics and Civil Morals, says that the king linchpin of modern accountability systems and the way to preserve social power is going to be the power of the professions. These professions are the new classes. They're not like the hereditary nobles, but they are new classes who have legitimacy in society based on forms of specialized knowledge that they bring. In the case of lawyers, right, they might even have the means and resources. It's amazing how every 19th century thinker thinks of the lawyer as the new aristocrats. They might even act as the new pastors because they have nice robes and a liturgy to go with it. It's a new form of status invention. And what would allow the judiciary to keep the other powers and parts in check is not the formal doctrines of constitutional law, right? I mean, law is only as good as it's applied. It is the identity of this profession as judges, as lawyers, right? Anybody who thinks of them as bearers in office of the law, right? So you might say the jealousy of the classes, right? The bourgeoisie, the nobility, the monarchy, is going to be replaced by the jealousy of the professions. The politicians, the lawyers, even the accountants actually in some sense are very key accountability functions in modern society, right? Okay. And each of these professions will acquire their own funny clothes, their own ritual status. It's a lovely modern reinvention of a different kind of social power now enshrined through the separation of powers. Wonderful theory, works in part, but notice the premise on which it works. The premise on which it works is the inculcation of that professional identity of that office as such a primary identity that it overrides any other political imperatives. And this theory got a big jolt, of course, in the Weimar Republic, where if you think of what went wrong with Weimar constitutionalism, right? And I really am closing with this. In the collapse of the Weimar constitutionalism, four things are very striking. The first, which is familiar to us, is the fragmentation of the center and the left, right? Which allowed the balance of political forces to be taken over by the right. The second, right, was that perennial problem in democracies, which is the problem of nationalism. The one question liberal constitutionalism has never been able to answer is the question of membership in a demos. Who gets to be a member of this demos, right? Who gets to be a member of the people? We can argue what the rights of the people should be, how free they should be, but there is no answer in liberal constitutionalism to the question. Who gets to be a member of that people? And the question of membership, which is the idea that the people should be constituted by not just an ethnically supremacist agenda, but an ethnically purist one, of course, which was the essence of the Nazi regime, right? The one regime that says a group of people should be extinguished simply because of being who they are, right? Right? That alliance between ethno-nationalism sunk Weimar democracy. But the third and most important thing, right, is the collapse of the authority of the professions. The jealousy of offices, this separation of powers that Montesquieu had placed so much of his hope on, completely vanished. So here's one example. Section 130 of the German Criminal Code, here is what one historian writes about it. This was a provision that had a clause against incitement to violence, and this is what the judiciary did. The provision against incitement to violence was interpreted zealously to target any social democrat, but the courts were reluctant to apply it to true reactionaries. In 1933, the German Bar Association submitted itself to, quote, coordination by the National Socialist regime. The historian Kenneth Ledford writes, within 5 months, a profession that 19th century reformers had considered the bulwark of civil society, which had viewed itself as a rock of independence, both from the state and from the public, bowed to the dictates of the party, which valued race over right. And I should just add, resemblances to any other bar association or country are purely coincidental. So if you look at this history, right, we like our constitutional histories to be usable past, the self-referential incantation of Sanatan Dharma values like the basic structure, eternally standing, guiding us to glory, right? The chief pastors of our constitutional church remind us about those kinds of usable pasts every day. But perhaps the usable past we need is to remind us of how fragile and rare modern constitutionalism is. I mean, if you add up the total number of years, it's probably not 30, 40 years in all, across the world, right? Modern constitutionalism is a magic trick, right, that has to be performed without any natural form of social power supporting it, right? But most importantly, it requires that jealousy of offices, right? That thing that goads the legal profession into its historical role. Ashok Bhai was much more good-natured than I am, right? But even he would, I think, have conceded that sometimes forewarning is better than self-congratulation, because to be forewarned is to be forearmed. Thank you.
Thanks. Thanks and thanks should be good enough after these stimulating talks by Fali and Pratap. I don't want to paraphrase what is said. That would be pretentious obstruction to drinks and dinner awaiting you. But I shall be failing in my duty for some acknowledgements I must make for making this function a success. Please permit me a couple of minutes. Our grateful thanks to Fali for his ready acceptance, for being chief guest, and most of all, to come in person. A big applause again, please. Our grateful thanks to Pratap to accommodate us for this lecture in midst of his hectic global travels. A big applause, please. Our grateful thanks to honorable judges of Supreme Court, High Court, past, present, and if I can add, some of them were kind enough to be standing judges today. They waited for the seat. We are very grateful for this patience. And also the judges who are online. A lot of them have promised, and they are in fact have joined online. It's very heartening that you took time off from a very busy schedule in midst of the week. My grateful thanks to Bar and Bench and LiveLaw who have live cast it and are going to cover it. Our grateful acknowledgement to family of Ashok Desai, particularly Suvarna Aunty, Harsh, Ami and Jay. Our thanks to Nitin Bhai, President of Bombay Bar Association and one of the foremost, senior-most junior of Ashok Bhai. Shyam and Madhvi, the most elegant couple, who have been rock support to Justice Pratik Jalan, Krishnan, Venugopal, Ritin Rai, Darpan, Parthiv Goswami, Vikram and all chamber colleagues. Now, you know, after 7, if we worked with Ashok Bhai, his Campari would come and wine was mandatory for us. So this is well past that time. And if we worked after 10, then the ice cream was also compulsory. So now you are in that happy time. Please join us for drink and dinner. It is mandatory.